I might kick things off. Thanks to you that have joined the webinar. Thanks so much. Hopefully it will be very useful for you. So today's webinar is on risk intelligence for legal professionals. It's going to be a little bit different to perhaps webinars you've seen in the past. So we're not going to have a whole bunch of kind of PowerPoint slides and things. We're actually going to have a kind of live Q&A with some of our expert panelists who I'm going to introduce you to shortly. The webinar is going to be recorded, as I mentioned earlier, so we know how it is. Everyone gets busy and can't always attend. So you can forward the link we send out to your colleagues, or you can watch it again in your own time. So the webinar itself, we're going to explore how law firms can cultivate a wide culture of compliance as a catalyst for growth and resilience. We've got AML juggernaut Amy, who's over from the UK. I'll do a proper intro to Amy in a second. And she's going to have a look at the benefits of integrating powerful risk sourcing capabilities with Actionstep. And this will help your law firm to potentially stratify clients for quicker intake and reduce risk exposure, access critical risks insights, and make better informed decisions, identify potential red flags proactively across the entire client lifecycle, and tailor enhanced due diligence for superior client experience. We'll also have a bit of a deep dive into things like the role of analytics and risk scoring capabilities and how these can be actually integrated with Actionstep. We'll have a look at techniques and reasons to risk profile clients, such as adverse media screening, PEP, and sanctions monitoring. We'll take a look at risk scoring and surfacing this across your law firm within the matter files and workflows. We'll look at risk insights and real-time data to help you make better informed decisions, and have a quick look at promoting cross-functional alignment, real-time knowledge sharing, and also streamlining your AML workflows. So I might just jump into the introductions. I'm Richard Jones. I take care of partnerships for Actionstep. Here, I work across the Australia and New Zealand region. And now I'd like to introduce Amy Bell, who's over from the UK, as I mentioned. So Amy is a compliance consultant. She's got a real passion for helping law firms adapt to, the fast-changing legal landscape. She also provides support for everyone in the law firm to understand compliance and how to actually apply risk management principles to improve that client service and the delivery of efficiencies we talked about just before. She's also a member of the Law Society's Money Laundering Task Force, and also the author of Solicitors and Money Laundering, which is published by the Law Society. We're particularly pleased to have Amy over here. Obviously, she's been through that whole AML piece when that was what came out in the UK, and so she brings some really kind of good insights in terms of how to avoid some of the pitfalls when this charge 2 eventually happens in Australia, just to make sure we're all completely prepared for it. Finally, I'd like to introduce you to Lisa Fernandez. Lisa is a senior account exec at First AML. She's been working in the legal space for quite a number of years now. She's got a deep knowledge of how AML works in law firms. But obviously, she's based in Auckland, and the New Zealand market has been through that, much like the UK. So between Amy and Lisa, they're bringing a kind of wealth of knowledge in this field to you. So just before we kick off on the Q&A, in relation to questions, I'm going to be monitoring any questions that you push through to us. We'll either answer them in the Q&A itself, or anything, if you want to shoot some questions through to us at the end, we'll have a section, 5 to 10 minutes, where we'll try to respond to your questions. So we might just jump into the Q&A. I've got a question straight off the bat for you, Amy. So why is proactive risk profiling for clients so critical for law firms, and why are legislators so focused on it?
So we're obviously in this period of time when the Australian government are considering how to implement tranche 2. I think it is a how and not a if. I'm pretty sure it is coming. Um, and when that happened in the UK, so we've had it for 21 years. When it happened in the UK, we had just a set of requirements that we had to do for client due diligence, and risk was there notionally, but it wasn't something that we needed to concentrate on. And in our journey with AML, as we've gone along, it's become more obvious that we need, as lawyers, to have the skills to risk assess both our practice and the individual pieces of work that we're doing, so that we apply the right client due diligence. Because if you don't have that step, what happens is you just do the same thing for everybody. If the criminals find that out, then they'll know how to get through your processes.
Right.
So, you know, you do want to have processes that are relevant to the type of risk that you're facing. And what we've seen, certainly in Europe over the time, is that they have made these kind of country type risk assessments. So in the EU, we originally had something called a supranational risk assessment, which was a risk assessment the whole of Europe. And that was followed then by a risk assessment by each member state. UK was a member state at the time, not anymore. But we have a national risk assessment. We've got 3 iterations of it now. We had our first one in 2015. And we're about to have one any minute now. They started working on the next one in the UK. And this is really critical, because what's the point of money laundering? Not money laundering. The point of money laundering is to get rich if you're a criminal. But what's the point of preventing money laundering? The point of preventing money laundering is to protect both the economy and society. And sometimes we miss that. Unless we kind of have flagged up to us by law enforcement in particular how criminals are operating, it's very difficult for us to be able to spot it. So first of all, for your country to understand across all the states and territories what the specific risks are, and to be able to disseminate that to the legal sector. So what we have in our national risk assessment is we will have a section that is for financial services, and that says how people use and abuse financial services for money laundering. Same for legal sector, same for accountants, same for real estate agents, and all the other different parts of the regulated sector. So really getting that kind of countrywide understanding of risk assessment is important. But then it's the cascade of that down into your day-to-day policies and procedures. So what will often happen is that there'll be this kind of national risk assessment, and then the supervisors, in your case, AUSTRAC, will translate that to what they're actually seeing on the ground. So theoretically, law enforcement tell us this, or law enforcement have observed this through some of their cases. We then need to think about, well, okay, if you're saying that, for example, property transactions are high risk for money laundering, that isn't to say everybody involved in property is doing money laundering. It is to say that the criminals are quite attracted by property to launder their money. So if you're working in and around the property sector, and that could be in real estate or legal, you need to understand how the risks are going to show up for you, what you're going to be able to see when you're doing your client due diligence. So, you know, large amounts of cash. And I don't mean actually, you know, foldy plastic cash. I actually mean, you know, just funds in the bank cash rather than funding a transaction. You'd be wanting to understand how that person came across that cash, whether that fits with the profile of the person. And if not, then you're going to want to make inquiries as to whether you think it's suspicious. When we talk about this kind of interplay between a risk-based approach and preventing money laundering, essentially what we're talking about is how much research do I need to do into this particular client to be comfortable that they're not a criminal? I mean, that's really the whole name of the game, is what we're supposed to be doing. And what often happens in AML programs is that we kind of get lost in the collecting pieces of paper for things, or collecting information for things, without realizing what we're supposed to be doing with it. So yeah, hopefully that's a good intro to risk.
Yeah, it makes a lot of sense. Is there any kind of examples of law firms you come across in the UK where they've gone into trouble over this kind of thing?
Yeah, sad news here, folks, if I'm honest. We've had this legislation since 2003, February 2003. It wasn't until 2015 when the legal sector supervisor really started doing proactive work in this space. It's not to say they weren't doing anything before, but it wasn't deemed particularly high priority, it wasn't funded very well. However, as soon as the regulators started to scratch the surface of compliance, and I don't mean just looking at the people that they had been told were involved in money laundering, I'm talking about just looking at people's programs to prevent money laundering. As soon as they started looking, they started finding problems. And in the last annual report from the Solicitors Regulation Authority, which supervises the solicitors in England and Wales, they found that only 30% of the firms that they'd had contact with, 178 firms they'd had contact with, only 30% of those were fully compliant. And that's after 21 years. So we're also seeing in many cases, I think it's somewhere in the region of 49% of matter risk assessments. So those are the individual client risk assessments that you're going to be doing. 49% of them were not completed properly or not compliant. So even though we've had the requirements for matter risk assessment for nearly 7 years now, June it'll be 7 years, we're still seeing widespread non-compliance. And you know, that's interesting to get into what the mistakes they're making and how can people in Australia avoid making those mistakes as they embed their programs.
Absolutely. Fantastic. Okay, I might jump into another question. So what are some of the key techniques and risk factors law firms should monitor?
Well, so you've got to understand your client base. That's the first thing. And the size of the legal sector in Australia, you've got some very big firms and some international firms that are here as well. And they've got a certain type of client base. And that will vary between those firms. Some of them will have different sectors that they focus on. So some will be doing kind of biochemistry type, life sciences type stuff. Some will be doing electronics and AI and exciting stuff like that. Some of us will be doing proper bread and butter mergers and acquisition work and construction and things like this. So you've got these big firms that've got these kind of clients that will probably range from everything to the person who comes in saying, please, can you help me? Somebody's died and I need to be able to sort their estate out, all the way to I'm doing a multinational, huge, billion-dollar deal. I need your help. And so they're going to have a huge amount of variations in their client base, and they have to identify them. They have to work out who they are. And quite a lot of Australia is smaller firms that have probably got a very similar risk profile. If I'm honest, they're servicing the local community. There's probably a list of services that they regularly deliver. So I think they'll find it easier to be able to identify the risks that they're dealing with because they haven't got such a wide, diverse kind of client base. So the first thing I think that firms need to do is understand, and this should start now, I think, start understanding who your client base is. Where do they come from? When you're doing risk assessment, you are the law, and we've not seen the law in Australia yet, but the law is based on international principles. So we've got a good idea about what it's going to look like in terms of for legal professionals. I say we've not seen it yet. Of course, you have already got AML law that applies to financial services, but they are looking at how to simplify what we've currently got in Australia to make it more easier to adopt for the kind of 100,000 entities that are coming into the scope. So you're going to need to look at the kind of clients you've got, the kind of work you do for them. So you might have a really low risk client, you might have a low risk client that, for example, is a fund, regulated fund or a listed company. And that will give you one type of kind of risk assessment. I think this is a low risk client. A listed company, has to go through so much scrutiny about what it's doing with its money. It's pretty unusual. It would be, practically impossible for them to be money laundering. It might be, I'm not going to get into bribery, corruption or AML scandals of big entities, but generally we think somebody's keeping an eye on them. They're probably low risk, but then they might want to do something really high risk. So they might want to, I don't know, obtain some assets from a high risk third country, a country that we're concerned doesn't have great AML processes. So you've got a low risk client doing a high risk matter, and then you're going to have to decide where that fits, and therefore what is the appropriate due diligence to do. after that. So clients, the types of work that you do for them, the way that you transact with them. What we know in the UK for the legal sector is that our client account, which is your trust account, is deemed as high risk by our government for money laundering. And that is because the criminals can move the dirty money through the system in your name instead of theirs once they can get it into the trust account. So it's really attractive to them to be able to get access to your trust account and ask you to move the money through the banking system because it avoids them being spotted. You've got to think about how you transact with people. Of course, there are certain types of transactions that a lot of legal professionals here will do that where they don't touch the money, it doesn't come through them. So, you know, those kinds of transactions are likely to be lower risk. They might go through a different payment method, like through PEPTA or something.
Yeah.
So you've got the client, the matter, the transaction, the jurisdictional risk. I just mentioned before high risk third countries. So when you've got a high risk third country is a country that is deemed by the Financial Action Task Force. That's the global body that supervises for AML. And if you're a high risk third country, it means you've made it either on their blacklist or their grey list. What they're essentially saying here is a country that has this risk rating, we're not confident that their AML procedures are legitimate or effective. And therefore, we'd like you to double check that they're not money laundering, because we're not just going to take it for granted because it's come out of this country that they're not money laundering. So you will often see places that hit the grey list or the blacklist where they're either well known for money laundering, corruption, bribery, things like that, or they're just not in compliance with the regime that is required. And but while I say that, a lot of the reason for the momentum behind Tranche 2, I think, is that the Financial Action Task Force will be coming to visit Australia in 2026. And currently, judging by the report last time, they were highly critical that the solicitors, real estate agents, accountants weren't being supervised. That could risk Australia going on the grey list if it wasn't rectified by then. And so that's partly why I think that there is some momentum behind Tranche 2 now. So once you've understood how you're engaging with your clients, looking at all those different factors, you need to make an assessment of them, and that's actually where we get stuck, if I'm honest.
Yeah, it's in Australia. There's a whole bunch of regional towns, and they'll have very different client bases to obviously the big cities, Sydney, Melbourne, and so it makes a lot of sense, definitely. Awesome. Might move on to the next question. So we talked about the need and the types. What are some best practices and how do they help with the decision-making processes?
Yes, so in the UK, a lot of what my business in the UK does is auditing law firms. So here they would call that a review, an independent review. We call it an independent audit in the UK. It's about 70% of the work that we do. So we see lots of people's programs where they've tried to get this right. And one of the trends we've noticed recently, and this is reflected by the regulators in the UK, is that even though firms have got risk assessment processes, they've had a go at building the process, the lawyers are still struggling with it. They're struggling to engage. So in that report I was mentioning, last year's supervision report from the regulator, we had 94% of firms had a process, but only 51% of the files had the process compliant. And so what we're seeing here is this kind of disconnect between somebody who's gone to the trouble of building a process, and by the time it gets to the lawyer doesn't really know what to do with it. And common things that I find in practice are they will observe the risk factors. So they'll point out the risk factors. The money's coming from overseas. The person is involved in a cash-rich environment. There's undue urgency in relation to this. These are all red flags that you'd be wanting people to be alive to for money laundering. They might reference all of those. And then when it says, so what is your overall risk rating? They get a bit stuck. Like they don't put an answer. So it's not that they're not doing the activity of considering the risks, it's that they don't actually understand the significance of them. So when we have risk assessment processes, there are a lot of yes/no questions. Is the client, a domestic client? Is the client, resident in Australia? Yes, no. is the client paying for this by way of their own funds or lending own funds? Like, we're not actually giving anyone a clue as to how to do the risk rating from these things. A much more effective way of that is saying the presence of these factors might indicate high risk. The presence of these factors might indicate low risk. Probably everything else is standard risk or medium risk in the middle. Okay. So we need to think when we're building these processes, how do we help people? Of course, you're going to have to do training about this. Once you've built a process, you're going to have to train it. But the thing with training is people kind of retain it for a little while and then they kind of forget. So what ideally you want in the most successful programs we've seen is where there's what's called just-in-time training. There's reminders just in time when the person needs to do it. And so, yeah, that's the first thing I would say about an effective program. The second thing I would say is about the timing of the program of your activity. And this is something that I think over the time we've been doing this, so we only got the obligation to do matter risk assessment in 2017. So we're 7 years in. And one of the things that I think people were used to doing prior to that was they did think about money laundering. I'm not saying we didn't think about the risk before 2017, but there'd be like one question on the file opening form amongst other risk questions that you might have. So other risk questions might be, can this client pay us? Is this work that we know how to do? Those kinds of things. Have we got time to do it? Things like that. They're risk questions. And they might have one question, do you consider a money laundering risk? Do you think there's a risk of money laundering in this matter? And everyone will put no. Well, in the UK, that's no longer enough. To just answer yes or no to that question will not be compliant. You've got to demonstrate you've thought about the aspects of the matter. And so when we were transitioning people from this one question to all of these questions, the question came up like, when do we answer this question? And I think you should be careful when you're thinking about this, because you definitely want to ask yourself a question like at the beginning when you're thinking about engaging with that person. I call that the barge pole test or a sniff test. If I think it's too like strange, unusual, scary, then I don't do it. That's your first look at risk. Oh, and you can only do that from the initial information that you've got from a client. You're not going to have anything else at that point. Really what you're asking yourself is, does this seem okay enough that we're going to go on to the next stage, which is to collect the client due diligence information that we need to collect them. So you've got the first stage, which is a sniff test, or the barge pole test, as I call it. Then the second stage is, so you've collected all of the client due diligence information that you want or need, or your process dictates. So that could be information about identity, passports, utility bills, could be identity about source of fund, information about source of funds, source of wealth, could be bank statements, wage slips, how they got this money, why they're doing what they're doing. Once you've got all of that information, I think you need to revisit your risk assessment, because you actually could only make a really light touch risk assessment at the beginning. It's not until you got all this information that you can actually evaluate, okay, so I've got all this information. We've been told this by the client, this is what they're hoping to achieve. And when I look at the information and the evidence that we've gathered, that seems to stack up, that seems to align. So you're wanting to check then. Now, the other thing about criminals, lawyers, legal professionals, they might not appreciate, is that the baddies can be sometimes quite patient. They can be. So what they can often do is get through those first two stages really easily. They'll present the stuff to you. It all looks legitimate. It all looks nice and neat and tidy. In fact, anyone who gives you more information than you're asking for, gives it you easily without asking for, that's a red flag in itself. I mean, why should they know what you're going to ask for unless they're what I call sophisticated users of legal services and they're doing it often, right? So someone comes along, I want to buy a house. If they suddenly turn up on the same day with all their source of funds, source of wealth information and stuff, you'd be like, why are you doing this? That's definitely a flag. Because baddies definitely know what you need to ask for, right? So when you've got all of that information, they think they're in there, and often they are in. Once they pass those checks, they're in, and you're doing the work, and you're getting ready to settle the transaction. And the thing is, the proper baddies will pounce at the last minute. So I saw a case once. about it was a conveyancing transaction, so a purchase of a flat. Someone was a student who had moved to a new area. Their dad was going to buy them a flat, and so the firm was instructed. The dad was going to fund the client's purchase, so they'd done loads of due diligence on dad, made sure they'd seen that dad had the money and understood that dad was likely to have £1 million for a penthouse flat that they were about to buy. Okay. And they were all happy with that. It was all vanilla. It was all very straightforward and everything. And then 2 days before completion, dad got in touch. He said, I'm really sorry, I haven't been able to get that money out of that bank account in time. It's got one of those bank accounts where I have to wait a few days after I've asked for it. So I'm going to have to bring in a bridging finance, so somebody with short-term financing who will lend me the £1 million, and then next week when I get the money, I'll pay them back. So it's going to be really short funding. And he said to the firm, can you help me prepare the paperwork for this? To lull the firm into this kind of impression that it was a legitimate arrangement. Now, so the lawyer did that. The lawyer completed, they got the £1 million in, they sent it to the other side, they bought the flat, and that was that. Now, fortunately, that lawyer actually left the business the week later. And the money laundering reporting officer, who was responsible at the firm, was looking through the files, checking everything was fine. And I found this very late change of instructions that hadn't been reported to them. And so they rang me and said, Amy, what should we do? And I said, well, do you suspect that this bridging finance person might not be legitimate? They're like, yeah, I do actually, because this is a typology. So in the UK, we have this suspicious reporting regime. Legal professionals are likely to get it here as well. So he did a report to the police and said, this has happened and we're concerned about this. And it turned out years later, as these things do take years later, that the dad was actually involved in some fencing, so some selling on of stolen art, and that he was a criminal. And in fact, you asked about the kind of things that you're going to need to do, and I'm sure we'll get into due diligence, but had the firm actually Googled dad, they'd have found that 3 weeks before they opened the file, dad was actually arrested in possession of cocaine. But because their process didn't have Google in it, it just had get ID and B, yeah. They didn't spot it. And the firm were under suspicion for a time by both the police and the regulators for, did you not do your job properly and let this happen? Because obviously our money laundering transaction had taken place. Eventually, the firm were cleared. The lawyer actually involved was disciplined about it. So, this is real, real life stuff we're talking about. And if we're not getting risk assessments and we're not doing them effectively. So the third stage for me, you've got your barge pole, after you've got all your evidence. The third stage for me would be just before you do the thing that could be money laundering, that you stop and you think, is everything still the same as when I did that risk assessment before? Because the change of anything significant, like a funder, like your source of funds, should trigger you to think, okay, is this changing the whole complexion of this? Does this now look like it might be money laundering? Is it going to change how I feel about it?
Wow. Yeah, it's I think probably quite a lot of the Australian law firms who are watching this haven't even thought about implementing any of these processes, steps, etc. Have you got any tips in terms of how they can actually start implementing these kind of things into their own law firms?
Yeah, so I do know that I was here at a law tech conference the other week, and I did hear from some of the law firms there. I think it was this week, wasn't it, actually? Time goes so fast. It was this week. Monday and Tuesday. And I did hear from some of actually the tech people in the larger law firms saying that that's definitely on their work plan for this year. I think a lot of the smaller firms will probably wait until they actually see the shape of the legislation, until they start moving on this. But in advance of that, what I can tell you is the hardest thing that we found when we had to adopt this was gathering the data to be able to let our lawyers know what would be unusual. So what I mean by that is we have got work types that we know and we do and we've done for ages. And we've got client bases that we service and we know and we've done for ages. And so one of the things criminals do is that they try and target law firms with things that are unusual for them in the hope that they won't spot the problems. They won't spot the typology. So yeah, I'm surprise, I've got another story for this, which was we had someone came to us referred in for from a sports law niche law firm. The firm just did sports law. And this client turned up to acquire a £67 million mansion in Berkshire, which was nowhere near where our office was in Manchester, like, I don't know, 200 miles away or something. But there's plenty of law firms near Berkshire they could have gone to and come to us. And of course, the first question I asked myself is, how did this client end up in a sports law firm in the first place when they were buying some property? This is what baddies will do. It was a baddie. It was an attempt wasn't in terms of buying it, wasn't money laundering, but there was a side deal that was actually the criminal activity. So you've got to start socializing these ideas with people. What is normal for us, and therefore what would be higher risk or unusual for us, and that will be in context to the practice, because you'll get large firms that do very complex, very complicated, very large transactions that are not odd for them, but if those kind of deals turned up in your kind of local high street or local town centre kind of law firm, that'd be weird and worrying, and probably outside your insurance cover, if I'm honest. But you need to start collecting the data so you can start to draw these conclusions about what's normal and what's not. And then I think until the law comes out, as I say, you don't really want to jump too soon because you're going to want to see what you're obliged to do. However, what you're likely to need to do, according to the global standards, you're likely to need to do this firm-wide risk assessment, sometimes referred to in financial services enterprise-wide risk assessment, but it's basically your law firm and what is the risks your law firm has. And this is why you're collecting all this data, in the whole. One thing about this, I would just caution. One mistake we've made in the UK quite a lot is that firms have tried to risk assess a department of their firm rather than the activities of the department. I'll give you an example. In the UK, buying and selling property is high risk for money laundering. Okay. And sometimes leasing commercial property, also high risk for money laundering. Baddies do it and set up cannabis farms in them. So, can be high risk for money laundering. But normal landlord and tenant work, lower risk for money laundering. So if all of that work is done in your property team, and you'd say, okay, well, then buying and selling property is high risk, then you're going to, that risk assessment needs to flow through some risk assessment. It needs to be reflected. So what you're going to have is your landlord and tenant people being treated as high risk when they shouldn't be. So when you're doing this observation of the work that you do, try and be granular about it to the different work types within a department. Don't just go and lump a whole department as high risk or a whole department as low risk. If there are some bits of it that isn't. That's going to help you later on, because the higher the risk assessment, the more due diligence you're going to have to do. If you're rating things as high when they shouldn't be, you're doing due diligence you don't need to do. And that's making things last longer, inconveniencing the client and you, and nobody's going to be happy about that.
Yeah, amazing. Thanks so much, Amy. So I might let Lisa start sharing her screen. And while she does that, I'll just give you a quick bit of information in terms of Actionstep and why we've really focused on this integration with First AML. So Actionstep is obviously a legal practice management system. It's completely cloud-based. It's completely customizable. And so in Australia, we're really trying to get ahead of the game here and make sure that we are integrated into fantastic solutions for AML like First AML. And so what Lisa is going to share shortly is a sort of high-level run-through of how the integration works. We've already got quite a number of clients utilizing it in both New Zealand and I think the UK as well. This is going to be real high level, so if you want to find out some more specific information of how it would work in your firm, just reach out to either myself or Lisa afterwards, and we would happily sit down with you and talk through how it would work specifically to your own firm. So might hand you to Lisa at this point. Over to you, Lisa.
Thanks, Richard. Hey, everybody. I won't spend too much time on this, but before I jump into the demo, I do like to give a bit of context to help our audience understand the value behind the tech I'm about to demo. So give you a bit of a background on how Source has been built. We've been around First AML for about 6 years now, and the focus has always been on giving our customers more of a holistic approach to AML rather than just focusing on one or two parts of the process. And we're traditionally known for our legacy model, which involved a team of AML specialists who leveraged our own technology to handle the AML process from start to finish on behalf of our customers. This became the first-hand learning bank that enabled us to design Source. It's a truly purpose-built end-to-end AML workflow engine, which I'll give you a glimpse into very shortly. It's essentially sophisticated enough to support businesses with all types of case complexity across different jurisdictions and risk appetites. And it's inbuilt with the necessary sort of automations, integrations, tech such as anti-tampering, biometrics, etc. And key thing with Source is it's highly configurable so that you can adapt it to your business and also the ever-changing regulatory landscape. We work with a range of industry types and support over 150 law firms globally now, trusted by some of the more prestigious names in this profession. The feedback from these customers is at the center of the product evolution. So looking forward to show you some of that in the demo shortly. So a bit of idea of where we sit in the market. Source gives you all the tools you need to drive the appropriate AML measures across all of your cases, not just the black and white ideal scenarios, but also edge cases where more sophisticated measures are required, whilst keeping that ultimate control around risk and client relationships in-house where it should be. So all of that sort of research and keeping things alive when it comes to risk that Amy's touched on, Source is designed to enable you to do that. And from a feature set perspective, you're getting tech tools to drive the necessary verifications as well as all the proven workflow tooling circled in the green there that we've identified necessary through our own experience having to verify all sorts of complex cases. So we're giving you very much an experience-based design, which we wouldn't have been able to do without the time we dedicated to being an outsourced service. So what I'll do now is jump into a little video I want to show you that demonstrates the integration between Actionstep and Source, hosted by our implementation partner Velata, who I must say support a fantastic implementation process. So I'll just play this video here and talk over it again. Richard, feel free to jump in and highlight anything you want to from your side. So we're looking at the action step view over here. And the first thing you do is create a matter as you normally would. You'd add your first AML case contact. It's going to show us that section shortly. So the Attenborough Family Trust. So the case contact is, let's say you're dealing with a company, it would be one of the key directors that you'd liaise with to collect the necessary information. Then you'd request for an AML case, and this is where you can capture your nature and purpose, your initial risk assessment, as well as your CDD level, and this will feed through to Source. And once that's done, we've now shifted into the view from Source. You can see that case is sitting in the in progress section to be progressed further. This manifest section over here gives you the opportunity to start the verification process. You can see risk assessment is one of the very first things that it's driving you to do there. And then once the cases, you can see those details around nature and purpose have fed through, you can also complete the other sections there. And in Actionstep, you'll have a summary of your AML cases, and you can actually view the progress of the case. So it's going to go into that case we created and show you, there's a little pinwheel showing you that the case is in progress, as well as how far we are with the verification of those two individuals. And then lastly, you actually get a case summary of the AML case stored in your document management system as well. So that's your high-level information about the case once it's completed.
Yeah, you may have seen in that little demo, action steps, as you probably would guess, is based upon workflow steps. And so we've got pretty much AML, the first or second step of any kind of matter, just so it ensures everyone in the law firm is addressing this. And you can also have mandatory tasks that have to be completed in relation to AML before they can actually progress in the matter. So that's a little bit around how the mechanics of the workflow is set up in Actionstep.
And here in Source, you can see that case that we've created is sitting on the dashboard for the user of Source. You can see it's in progress. So if I just click on that one here, it's now got a whole list of cards that demonstrate all the activities that need to be done. You can see that the risk assessment is one of those things. And in this tab over here, you've got a couple of options here. You can complete the risk assessment within Source. You've got a list of questions over here. You've got yes or no, as well as the ability to leave comments here. You can also, if you've got this set up centralized where an administration team is running the AML process, this can actually be sent out to the author so that you've got someone from frontline completing this. You can see it captures a version history as well that really supports what Amy's saying over there. This is designed to be a draft that stays alive throughout the relationship with your client. And the other thing that's really helpful in terms of making sure that you're setting the right expectations with your team, giving them a good template to use, is that within this settings section over here, how we set up Source, you've got a preset suite of rules to choose from. So it's an if this, then this scenario. So for example, if you've got a trust, it's going to suggest collecting a trust deed or amendments. If you've got a PEP match, it's going to suggest source of wealth. So this is a really good way of making sure that your team are actually consistently completing AML the way that they should. And you can also add your own rules. So if you're finding as a compliance officer, your team are coming to you with a lot of questions around this area, it could be a flag that there's some training required there, and also that a rule needs to be put in here to really guide that team. You've also got the ability to add your own requirements. So we know not everything is black and white in AML. So sometimes people aren't going to have the right documents, or their passport's going to be expired, things like that. So you've got the ability to collect other documents as well. And you can also add your own requirements here as well. So maybe you want to collect further information to get to know your client more, like the type of occupation they do. You can add that in as a requirement, and the option for a short answer, some manifest description here, which is a place for you to put some shadow text to really guide your client. So really helps you set this up in a way that's going to be super supportful for your team as well as your clients. These are just some of the key things I wanted to show you in support of what Amy's talked about during the discussions earlier. Another thing is around how important that implementation process is. We really sit with the compliance officer, understand their process, and how we can configure this to best support where they're at on their journey of compliance.
Awesome. Thanks, Lisa. So I'm just conscious of time. We've probably got 3 or 4 minutes left. We've had a few questions come through. I'm just going to have a quick scan. Okay, this is probably a nice quick one. So for law firms getting started with this whole AML piece, I guess it's for you, Amy. What would you recommend as a really good first step?
A really good first step would be to get some training on it. That's an obvious point to make, but one of the things, obviously, we're waiting to see what the law will look like. We're waiting to see what the requirements are for a program. But as I said earlier, the AML requirements come down from global standards. So they won't drift too far from that, or else they wouldn't be compliant. So understanding how money laundering happens in Australia is going to be really important. On my second visit here, I've spoken to lots of different people in lots of different industries, including banking, and there is there's a perception that it's only an issue with foreign money. I don't think that's right. In fact, this week I recently ran a poll in the UK and said, out of all of the reports that you've ever made, bearing in mind we've had the legislation for 21 years, if you're a money laundering reporting officer, did your reports include people who were domestic, UK citizens? Did it include overseas citizens, and did they include both? And only 4% said overseas only. So 96% of the money laundering reporting officers, I think, had 82 votes so far. 96% of those said they'd spotted money laundering or thought they'd spotted money laundering domestically as well as foreign. So I would definitely recommend that. There's a book called Nathan Lynch by a guy called Nathan Lynch here called Lucky Laundry, which is really easy to read, easy to digest book talking about how money laundering has become a problem for Australia. And I do think getting some early kind of knowledge of that, so that you can start to think about how you might be targeted. It's always useful to look at international publications around this. So the IBA, ABA, so the International Bar Association, American Bar Association, and the Combined Bars of Europe published something quite a few years ago now, which was vulnerabilities in the legal sector. It's still pretty relevant. And that's really good reading for you to see what the risk factors are you're likely to want to be able to spot. This is a global, attempt. And I do know that that people in Australia contributed to that paper. So I think that would be a really great thing to read. Awesome. And also to start to think about the notion of client due diligence. So the stuff that Lisa was showing you there, it's really split into two things. The first one is, do I know who my client is and where to find them? One of the things that I kind of have observed in the UK is that a lot of focus gets put on identification and assuming that if you know who they are, they can't be a money launderer. Now, when I say it like that, that's obvious that that can't be right. But funnily enough, programs grow up just focusing on identity. Now, identity is really important for lots of things, including fraud. So we do need to do identity, but in an AML context, try and always remember, if I teach you nothing else, it is that ID and V, which is the ID documents or the electronic verification checking, it's simply about having a door to knock on to find the person should law enforcement want to speak to them. The real opportunity to prevent money laundering is making sure we're not involved in transactions that have dirty money in them. And so when you're doing these kind of early reflections on your practice, it's transactions that are likely to be in scope, because that's how money laundering happens. The whole point of money laundering is to transact it so many times that nobody can work out where the money came from. That's the whole point of it. So thinking about how you might be exposed to that. Because building a program that not only focuses on the identity, but also addresses the question, do we think that this transaction is part of a money laundering scheme, is the thing that's going to keep you safe. So yeah, those are the things I would do. Awesome.
Thanks, Amy. Hey, we might wrap it up now. We've got a few more questions, but we'll respond to them, to the individuals that sent them through. I'm just conscious we want to keep this to around 45. Thank you to everyone who attended. As I said, we will send out the link so you can share it with colleagues or watch again if you like to. Thank you very much to Amy, who I know is heading back off to the UK later today. Much appreciated. Thanks, Lisa. That was an awesome demo. And yeah, feel free to reach out to either Lisa or myself if you're interested in seeing a demo of Actionstep or First AML. I'll leave it as that. Thanks again.
Thanks, everybody.
Thank you.
See you later. Bye.
Bye.